Welcome to our channel. The goal of this channel and the podcasts that we're going to be publishing is to educate the general public on recent Nevada Supreme Court decisions so that you can know what your rights are in various fields of law. All right, suppose you are a miner out in the old desert of Nevada and you have a mining claim and you're feeling pretty weak and it might be your last few days on Earth. And civilization is a long way away from you. Your horse just died and you don't think you could walk to the nearest town and survive. But you know that you struck a vein of gold in your silver mine. And you have next of kin on the East Coast that you would love to have this property. But you want to, of course, disinherit certain relatives that are no good scoundrels. So you don't want to leave it up to the probate court to do an intestate succession disposition, which would be looking at all of your close kin and then evenly distributing it among them. You want to say which ones can get parts of your mining claim and which ones cannot. But there's no lawyer around for miles. You don't even have witnesses, no neighbors. And even the neighbors that you could call upon, you don't trust. They might just kill you and claim the mine themselves or something. Go in and mine it while you're dead and steal all the gold out of it before anybody even knows you're gone. So you're quite concerned about your property and your few remaining days on Earth, and your children or grandchildren and their futures. So what can you do? How do you make sure they get the property you want them to get? Well, the Nevada legislature knew that this was a possibility, and they allowed what we call holographic wills. This is a will that you handwrite and you date and sign. You have to be over the age of 18 to do it. And you can then send it, mail it, to whoever you trust to receive it, to make sure that they open a probate and make sure that your beneficiaries get your property. In your holographic will, you can also say what you want to have done with your remains. Holographic will is a very quick, very easy way to explain your last will and testament without the need of witnesses. Other types of wills, if you don't handwrite them, they're not holographic. If they're typewritten, then you're going to have witnesses. Uninterested witnesses sign it. You should have a notary public. If a lawyer drafts a will for you, you're going to have witnesses. And it's going to cost you a lot more money. And it could take days to draft. Because a lawyer is going to want to dot every I and cross every T and put all kinds of language in there to protect the lawyer and further complicate it to make sure that the heirs come back to that lawyer to help explain it and help divide the assets and open probate and so forth. So if you want to do a cheap, quick holographic will for any reason, you can. Nevada Revised Statute, I'll read the entirety of the statute, it's very short. NRS, Nevada Revised Statute 133.090. A holographic will is a will in which the signature, date, and material provisions are written by the hand of the testator, whether or not it is witnessed or notarized. It is subject to no other form and may be made in or out of this state. So you can write this anywhere in the country. Every person of sound mind over the age of 18 years may, by last holographic will, dispose of all of the estate, real or personal, but the estate is chargeable with the payment of the testator's debts. That just simply means creditors will get property before your heirs will. Such wills are valid and have the same force and effect as if formally executed. Why might a family lawyer who doesn't really do wills or probates know this information and maybe even convey it to prospective clients or existing clients? Well, there are scenarios where, believe it or not, clients are afraid their ex is going to kill them. Maybe prior to the divorce trial. And so they can put something in that will that says, in the event of my death, I don't want my spouse, they're not exes yet because the divorce hasn't finalized, and as a spouse they would get everything. And they probably would get anything even if everything even after the will, they can contest the will. But at the very least you can put in your will that you don't want your spouse to have your remains immediately cremated. That if you die before the divorce, you want your body to be protected for further investigation, as it could be a suspicious death. So I've had people concerned like that before. I've also had people come in who are very elderly and they have a trust set up, but the trust wasn't fully funded or there were problems with the trust. And so there's property that isn't accounted for by the trust document. And since they could die at any moment, they don't want to wait days for a lawyer to gather everything and figure everything out. So they can actually sit there in the office with the lawyer and write out in their own hand a holographic will explaining that any property not mentioned in the trust should be placed in the trust upon their death. It's called a pour-over will, done holographically. They could, of course, also do an amendment to the trust or actually fund the trust before they die. But the holographic will is just a quick way to immediately do something in the event that they die before anything else can get done. So those are the benefits of a holographic will. You can do it yourself. You do it in your own handwriting. You can do it any place in the country, even if you have property in Nevada. Say you're about to get murdered by gun. Or say you've been shot and you're lying dying in a grocery store. Handwrite with your blood on the floor of the grocery store your last will and testament. It doesn't have to be long. That can be enough. I would hope that you might, if you knew who your assailant was, put their name or something, if you can identify them. But absent that, if there's something you want somebody to have and you know you're bleeding out, write it in your own blood, or write it with whatever a writing instrument you have, a pocket knife, a pencil, a pen, whatever. Lots of reasons why it's good to know about a holographic will in the state of Nevada. Lots of that. I mean, it's designed for imminent death. That's the point of it. Old mining claims and so forth, where there is nobody around to help you. But it has to be in your handwriting. If you type it, it might not count. That begs the question of whether you can do a holographic will by video. No. Holographic will has to be in your handwriting. Certainly, if you're videoing yourself writing out the holographic will, that can bolster the evidence in a probate case that you actually did handwrite it. So if you have a cell phone as you're lying dead in the supermarket, lying dying in the supermarket, bleeding out, turn on your camera and show that you are writing out on the floor or whatever surface your last will and testament. It's going to be hard for anybody to deny it was you doing it. So anyway, that's the value of a holographic will. I'm Nevada attorney Anthony Wright. Please subscribe below and leave comments, but remember, comments are not confidential in a public forum.